Good afternoon and welcome to the regularly scheduled meeting of the Oklahoma City Board of Adjustment for May 3rd, 2018. Before we call the meeting to order, just a couple of quick things. If you would, flip your cell phones to silent for us. We would appreciate that. Also, if you have not signed up yet to speak today, but you want to be heard on an item, one of these white slips can be found in the paper or at the table outside, and you can provide that to Cindy here up front, and she'll be glad to provide that to me, and I'll call you at the appropriate time. When you do come up to the microphone, if you would, start out by giving us your name and address for the record, and then make sure you adjust that microphone so that we can all hear you. And with that, our first order of business is to receive the minutes of the April 19th, 2018 meeting.
I move to accept the minutes.
I second.
I have a motion, a second, to receive the minutes from the April 19th, 2018 meeting. Please cast your votes. And the minutes are received. Next item is continuance, requests or withdrawals from staff.
We have one continuance, item number 5, 14477, wishing to be deferred to the June 7th, 2018 meeting.
Again, that's case number 14477. Was there anyone here that wanted to be heard on that matter today? If not, I'll take a motion on the continuance.
I move to continue 1447.
I'll second.
I have a motion and a second to continue case number 14477 to June the 7th, 2018. Please cast your votes. And the application is continued. Are there other requests? Anybody else here want to be heard on a continuance request that's not been mentioned? No? Okay.
We have item number 1, case number 14451, request for variance to the maximum 30-foot sign height and 200 square foot sign display area in PUD 249 district located at 3400 West Memorial Road.
Good afternoon, David Box, 522 Colcord Drive. I'm here today on behalf of the applicant. With me is Tim Johnson, civil engineer for the project, and Eric Gransberg, the sign vendor for this project. What we are seeking today is a variance to allow the erection of a 50-foot sign along Memorial Road. As well, we're seeking a variance to the size. As you all know, this is a variance application is guided by the statutory conditions outlined by our legislature. I think a lot of times, I know myself, I personally get involved in a case and I fail to really go through each element. What I'm going to try to do is walk you through each element, explaining why we meet each of those elements required. The first element, that the application of the ordinance to the particular piece of property would create an unnecessary hardship. Here what we have is an ordinance that was passed prior to the erection of the Kilpatrick Turnpike. So when this PUD was approved by ordinance, the developer at that time agreed to certain size limitations, that being 30 feet in height and 200 square feet in area. When he did that, he was doing so without the knowledge of what was going to be facing this property long term. Long term came several years later when the Kilpatrick Turnpike was built, and ultimately fly bridges were created. And if you look at the image before you, you see that you have a significant embankment that I believe totals 30 feet right in front of the subject property. So we would submit that the application of the ordinance creates an unnecessary hardship by limiting the view of a sign anything other than 50 feet. To prove that and to show that, we do have a video that I'd like to show you that somebody's going to have to. There we go. Ms. Lincoln, if you push pause real quick. What you're viewing here is a car going westbound on the Kilpatrick Turnpike. What you're going to see on the left here in a little bit is the subject site. Mr. Gransberg, the sign vendor, was able to get out there with a bucket truck and raise it to 50 feet. So we can then transpose the image of the sign so you can see the view of that sign at 50 feet from the westbound drive. Ms. Lincoln, if you'd push play. If you push pause. So again, this is right when you have to make a right to get in the right lane to be able to exit, if you're going westbound on the Kilpatrick, to be able to go back under the highway and then take a left to get on Memorial Road to get to the Mathis Brothers property. So if you push play, that's at 50 feet. This is at 40, if you push pause one more time. So as you can see at 40, that's all right, at 40, the sign is obstructed. You're not going to be able to see what it is. You can't read the full board to see, if you're looking for the Mathis Brothers property, where that is. It's a partial sign at 40 feet. Certainly at 30 feet, which is what the ordinance, the PUD, would allow, you're not able to actually see. And so one of the other elements we have to prove is that the application is the least necessary to alleviate the hardship. It's our belief, and I'd submit to you, that this video shows that the 50 feet is the least necessary, because at 40 feet, you can't see the sign. It's obstructed, and the message would not be able to be read by the intended recipient, that being the reader. So again, the application of the ordinance creates the hardship because this condition did not appear at the time the applicant would have had that ordinance passed, that being prior to the construction of the Kilpatrick Turnpike. Next, the next element is that there's something peculiar about this piece of property. Again, it's in the same vein. You've got a 30-foot embankment with a turnpike built on top of that, and then west of that you have fly bridges. So you have significant obstructions that would not have been in place at the time that the ordinance was passed, allowing the 30-foot sign. Next, the element is the relief, if granted, would not cause a substantial detriment to the public good or impair the purposes, intent of the ordinance or comp plan. The book you have in front of you has a series of exhibits, some of which Mr. Johnson will go through. The one I want to touch on this particular element in the statutes is going to be found, let's see, the 5th page. And the 5th page looks like this. It's a series of other signs up and down the Kilpatrick. And so if we think about what is meant by the relief, if granted, would not cause substantial detriment, to me that means, is this going to be out of character? Is this out of place? Well, what you see up and down the Kilpatrick Turnpike are similarly situated signage. And in fact, in the image you see right there before you, if you look to the right, you see the Rudy's sign. So signs of approximate height of what we're seeking is not uncommon, and this area is one of the fastest growing and thriving areas in the city. And if it's been able to thrive and exist with similar signage, I would submit to you that the relief we seek would not cause a substantial detriment to the ordinance or the public good. Finally, again, the relief is the minimum necessary. We believe the video shows exactly why it's the least necessary. The 40 feet just doesn't allow the signage to be read. Several other exhibits in here that Tim will go through, but I do know that there is some concern, and I think you have some protest here today. So when you look at this, the first page, what it's showing you is where our proposed sign is, and then you see that bottom left image. That is the bucket that's put up to the 50-foot mark, and then all of these images are shot with the sign erected based upon that bucket truck. So what you can see in the first image is from that first street, the first residential street south of our proposed location, you can't see the sign. The next page, you'll see that you can just start to see it if you're standing 16 feet off the ground from those houses south of us. And it's worth noting, this PUD that's in place that governs all of this, everything north and west of the neighborhood is all zoned heavy C3, meaning you could have significant commercial, significant tall buildings built through here. I mean, you already do have the 2 hotels that are built here that have significant height. And then if we move to the next page, what you'll see, and you see a grayed out area, what this is showing is the ability to view based upon the existence of the buildings that are there. So the area that's grayed out, you really can't see the sign based upon elevation and the existence of the buildings that are there. The next image just goes through the distance from the only 2-story house that's along that stretch to the sign, and it's over 500 feet. We already talked about the image with the other signs. The only other image I'm going to touch on, then I'll turn it over to Mr. Johnson. If you go to the last page, what you're seeing is, because this is the boards are shaped like a V, the area that's grayed out at nighttime, you won't be able to see any part of the EMD sign. The reason we were able to produce this image, if you go to the page before it, Mr. Gransberg, the sign vendor, has a similar sign, and the image before that shows you that exact sign as erected, taken from behind it, and you can see from certain angles you flat out cannot see the EMD board because of the shape of the board. So, with that, I believe that this application meets all the necessary elements for a variance to be granted. This is the exact reason why we have a variance process. Perhaps the question might be raised, why not go zone it? Going to rezone a piece of property for one single item such as a sign is disfavored. The Planning Commission routinely says we don't want to see applications for one item, and perhaps Mr. Cravens can agree or disagree with me on that point, since he also sits as a member of the Planning Commission. But this is why we have the variance process. If there are certain elements that just can't meet the code as written, there are conditions laid out. And I would submit to you that this is certainly one of the more unique fact patterns because of the timing of the turnpike and the obstruction that creates that wasn't contemplated at the time that this development was approved by the City Council. So with that, we believe we've met all the statutory conditions, and I'd be happy to answer any questions. And if not, then I'll turn it over to Mr. Johnson.
Board members, questions for Councilor Box at this time?
I have a question. On page 2 of the staff report, the negotiated sign, PUD 249, discusses the limitations and parameters of the signage. Is that correct?
Yes.
And that language was negotiated as part of the approval of that PUD 249. Is that correct?
I don't know. I mean, this is such an old PUD that I'm not sure what the specifics were and if that was a key piece. I mean, there are, I believe it's 7 pole signs allowed. There's a pretty significant sign package because of the amount of land that was at issue at the time. But certainly, if it was agreed to and that was a point, they could not have contemplated what the after result was, that being the Kilpatrick Turnpike.
Okay, but in that particular case, those signs are limited to 30 feet in height. Is that correct?
That is correct.
And as regard to the illumination, requires that the permanent signs be internally lit. Is that correct? And not be illuminated?
That's correct. We don't believe we need a variance for the EMD. The EMD is permitted by right. And JJ's nodding his head, I believe in agreement. The variance is just on the height and the square footage.
Okay.
We believe we are allowed EMD by right.
Okay.
They'll operate the EMD in accordance with the base zoning.
Okay. I have questions on the other ones, although they're not necessarily relevant to this particular application. The ones that showed the Sonic, Rudy's, IHOP, et cetera. Were those, do you know when those were approved or the circumstances or anything about those peculiar?
I don't. They weren't part of this PUD, so I don't know when they would have been approved, but they're of a similar height.
Okay. Thank you.
I know the Rudy, I think that they're all post when this PUD would have been approved. In terms of the erection of the sign, I know that that's the case.
The one other thing, the corridor issue always comes up on Broadway Extension, where you're the signage and the argument that you can't build your signs up to be reflective from the corridor of the Broadway Extension. As I understand, there's not the same requirement for Kirkpatrick. Is that correct?
Other questions? Mr. Johnson?
Tim Johnson with Johnson Associates, back here again on this application. And since we continued this the first time, we have met with the property owners, one in a large group and then a second time in a smaller group. We visited the site. We talked to the neighbors that have the second-story window looking north. And I really have tried to, we moved the sign from our original application, moved it to the west, and, just tried to prepare the information that's before you today to show that our impact would be minimal, if any, on the properties, the residentials to the south. If we go ahead and finish this video, there's a second video I want to show you. That is it was taken immediately north of these residents. So this is we're westbound on 135th Street, which is the street serving the office complex north of the neighborhood. If you look back on that, the very decorative wall and the trees planted along there are all adjacent to those houses. And you can see from this angle, you can't see any window edge or barely see the below the roof edge on most of these. So right between these buildings is the two-story window. And then we see it again right here. The house to the left has the two-story window. So that just kind of gives you an idea of elevation-wise, this site is higher, their sites are lower, and it continues to drop to the south as you get into Quail Creek. So on the third page of the drawings we've provided to you, fourth page, I'm sorry, it shows a distance to the subject house that we mentioned has a two-story window at the high level. It's almost center in the building, centered on the building, and it's approximately 525 feet away. And, you know, ironically, there's two office buildings on either side of their house, and so their window has a view looking between those two office buildings to the back of this building. And then if you skip the next page, and you can shut that off. What we show, this is from the flyover, which, as you all know, is way up in the air. What we've done is superimpose an additional development. There's vacant land there that'll continue to be developed as time goes on, and we've stuck a development in there, another hotel site, and you can't see the 50-foot sign from the flyover even until you get around to turn north, and it's just to kind of give you a feel of, on the next page, you kind of get a feel for the scale of things relative to buildings and the highway height. And if you keep turning, the drawing that has the blue and yellow, so on the video where we were showing westbound traffic, the MUTCD, which is the international traffic manual that's used for various traffic issues, at 70 miles an hour, a safe distance to make a decision to change lanes, to stop, things like that, is approximately 1,500 feet. What's in blue is 1,000 feet, and that shows about where we come over the bridge. And then, which we feel, MUTCD is probably conservative. 1,000 feet is easily enough to stop if you're in the right lane and make the exit. And then, as David showed on the other video, if you can see the sign in enough time, you are able to leave the highway if you're in the right lane before you hit the gore point of the exit ramp. And then the following page, this is an example of what the sign will look like as far as construction. Many of you have seen these where they fan out in the back. This particular sign in this image is one that's located at the Gold Key Gym at MacArthur, west of MacArthur on the south side of the highway. And so the fan width in the back of this is not quite as wide as, this is 15 feet, ours is going to be 25 feet. So the fan width is wider, so that means less of the sign will be seen from the back. That just gives you an idea of size and style. So I think David mentioned a little bit about this, but let me explain this. So at the Gold Key site, we went out there and took these images at night. You can see it's dusk and then it's pitch black. That was shot at an elevation above the ground of approximately 25 feet, looking back at the sign, 500 feet away from the sign, really to mimic the second-story window of the house. And as you can see in these three images from the various locations we shot, that's why we show that as a shadowed area, is you virtually cannot see any part of the sign that far away. The EMD is oriented towards the highway. The back of the sign is black and dark. And I believe last is, so that shadow image was overlaid from the top view to the bottom view, was overlaid on our condition, and it certainly protects the house in question that has the second-story window looking north. And that's what we're trying to show in that image. And so that explains all the imagery that I've provided to you. Do you have any questions of me?
Board members, questions?
Thank you.
So we have a number of folks who are signed up to speak on this. I have some questions for the applicant, but I think we'll hear from them first. The first person I have signed up to speak today, and please, if I mispronounce your name, forgive me, but Jay, is it Spradling? Is that correct?
My name is Jay Spradling, 1320 Reese Court, Oklahoma City. I'm a lawyer representing the applicant. The nature of what you've just heard is a request by the applicant to obtain a variance to benefit his business that is, in effect what he's saying is, we'll make more money if we get a different kind of sign. We want you to give us the ability to raise the sign. There is no showing that this property is unique. There are 6 other pieces of property adjacent to this in the Memorial Business Park subdivision. I think you have that information available to you. Papa Doe is on the adjacent lot to the west. They have a limitation on their signage, limited to a monument sign, no EMD, and no pole sign. They could be looking at this opportunity as a means to come before the board and say, you granted a variance for the sleep center, we want a variance for our site. We want a 50-foot pole sign and an electronic message on the top, or a monument sign with an electronic message on it. The hotel, Holiday Inn, could make the same argument. All these properties are affected equally by this ordinance. There's no showing that this is unique or that this situation is peculiar. Furthermore, the grant of the variance would cause substantial detriment to the purpose of the ordinance. We submit that this sign does not address the issues that the neighbors to the south have, and that there is no evidence presented to the board that the relief grant is the minimum necessary to alleviate the unnecessary hardship. Well, first we take the position that there has been no unnecessary hardship shown, and that they've shown you that a 40-foot sign can be seen. You can't read the whole thing, but there is a way that you can see it. We're not suggesting that we're in agreement with a 40-foot sign, but I think the showing that this is a minimum is inadequate, does not meet the statutory requirement. Furthermore, the purchaser, the applicant, bought this property in 2013. All these factors that they're complaining about were in existence at the time they bought them. So they're asking you to waive the sign requirement because they made a mistake by not understanding what the effect of those sign requirements were in the ordinance. They had ample opportunity to avoid the purchase of this property and go look for something somewhere else if they thought that was such a viable part of their business plan. Furthermore, there's a declaration of covenants, conditions, and restrictions that have been applied to this property, covenants that run with the land, that adopt all the same sign restrictions as contained in the PUD. So this is only the first opportunity they need. The Board of Adjustment doesn't have the power, doesn't have the jurisdiction to vary the terms of covenants that run with the land. The only body that can do that is the District Court of the State of Oklahoma. So in order to get this sign built, they're going to have to go to the District Court and apply and show that there's been a change of condition such that the literal enforcement of this covenant would work an inequitable situation upon them, which, in our opinion, they can't do. So that concludes my remarks. The developer is here who can speak to some of the issues with regard to the intent of the height restrictions and sign area restrictions, and then some of the other people that are here can speak to the issues as how they affect residents in the South. If you have any questions, I'll be happy to try and answer.
I just had one comment. I mean, you haven't been able to review this.
I've not
yet.
received a copy.
Okay. I think it's fair that any of the protestants should be able to review this. I mean, it's well done. It's very persuasive. So if something's inaccurate, I think it's fair that you could raise that to the board's attention.
I'm sorry?
That's all. If there's something you disagree with or something in there, I think it's fair to give you an opportunity to bring that to the board's attention.
I mean, I accept these at face value. But the purpose of these is to show you how their business would be benefited, that they could make more money if they have a different kind of a sign. And economic hardship isn't the kind of hardship that the Board of Adjustment needs to address. There are many cases that say economic hardship or financial hardship is not the purview of the Board of Adjustment to say.
Yeah, I understand. I just thought it would be fair to give you an opportunity to review that.
I mean, I accept this at face value.
If there are other people who would like to see that exhibit that are here in protest, please take a minute to review that if you'd like to. We can circulate one. So I think Mr. Merchant's point's well taken. So additional questions from Mr. Spradley?
Question?
I would just make a couple of comments based on your, or a couple of remarks based on your comments that I want to make clear. Every business wants a sign for business purposes, right? That's what signs are for. They're to advance someone's business interests. I didn't hear the applicant claim an economic hardship in their case about defining the hardship. We're going to talk about that in a little bit, but that's not, I don't think, fairly articulates what I heard from them. The other thing I would say is, remember, every one of these cases is unique. They're all viewed differently. In fact, the applicant made that point in showing other signs along this corridor. While those help establish that there are credible reasons, maybe, for example, the existence of a hardship that would dictate necessity to alter the ordinance that's provided, they have no real bearing on our review of this application, nor would a future case have bearing on the board as it relates to the way it ruled on this application, because they're all looked at individually, right? Another thing I would say that I think I want to make clear, the board, you're right, the board is not here to review the covenants, the private covenants that were maybe affected the land at the time of purchase. What we decide here today has absolutely nothing to do about the private rights of other members, other owners that are affected by those same covenants to enforce those rights. That's not what we're here to decide, and certainly our ruling would have no bearing on those covenants. The last thing you said that I think I would point out, just so you understand, there have been, again, while all are looked at differently, there have been instances where people come in and argue about what I would say are topographical obstructions of elements that could not have been contemplated by someone who drafted an ordinance and said all signs are going to be no higher than 30 feet. There's a specific case that comes to my mind that was just pretty grossly humorous about where that was located, how it was zoned, and the way the ordinance would have been applied there. To me, that element did create uniqueness, and there was a hardship there that was clearly established. So I think there are instances, I'm not saying that's the case here necessarily, but there are instances where those sorts of things do affect the review of that ordinance as it relates to whether or not a situation is unique. No, there's not anything unique about a commercial site that wants a sign. I agree with you there. So I just wanted to take a minute to address, you made a lot of comments there, and I just wanted to address some of them publicly before other people come up and speak additionally on other comments they may have.
Well, I'd like to respond to that,
Go ahead.
if I might. I take exception to this statement that there was, by implication, a financial benefit that they're seeking with a higher sign. I mean, everything that they said is that talked about the marketing opportunity that a higher sign would create. That's dollars.
Well, but to come up here and say that they don't want it for business reasons would be laughable. I would laugh at them if they didn't tell me that they wanted that sign for business reasons. Of course, that's why they're applying for the application. But that's exactly why signs are there. Signs are there because businesses want to be identifiable from as many people as possible, and that's why they're allowed by code, right?
But correct. But the issue is that they bought the property knowing that there was a limit of 30 feet.
I understand.
And it's in the covenants as well.
Yep.
So that in due diligence, if you're to spend the kind of money they probably spent on this property, you'd investigate that. And we assume that they did. They were fully aware that there was a 30-foot limit. They bought the property, and now they're trying to get out of it because they think their business would be benefited by a higher sign. Same with Papa Dough. Papa Dough could say, and you know as well as I do, that the precedent that one case, or one zoning case could set, tumbles down. They can use it as precedent for another zoning case. And we feel the same thing about Papa Dough. We want a 50-foot sign. Holiday Inn wants a 50-foot sign.
I understand the slippery slope argument. We hear it very regularly. Again,
yeah.
The point I want to make before I call the next person that wants to speak on the matter is just that these cases are reviewed on an individual basis. So no precedents are set where we say, well, because we ruled on one matter this way, we must rule on all the other ones the same way. That's not the way that works. So I do appreciate it.
All right, thank you.
Thank you. The next person signed up to speak is Hugh McCoy. Welcome.
Hi, how you doing? My name's Hugh McCoy. My address is 3421 Stonebrook Court. And yes, I do own that two-story house that's been referred to here a couple times. Now, my wife is also signed up to speak, and she's going to speak about the personal nature of our concern. So I'm going to stay away from that because she's a little more emotional about it than I am, even though we both are. So we'll let her get into that. I want to talk about some of the more important things that affect us personally. We closed on this house just a little over a year ago. And one of the reasons we picked this particular house, and the reason that it is a two-story house, is because we have a dependent child that suffers from a traumatic brain injury. Those windows face the north. They don't face the south. They face the north for a reason. That's because that's where her bedroom is, and that's the least amount of light that she can get. She requires medically 10 to 12 hours a day of sleep. We totally blocked those windows off. If you look closely, which, by the way, I appreciate you guys giving us this. It would have been nice for us to look at it a little bit beforehand. In the second meeting we had, I specifically requested this information, and this is the first time I've seen it the last 30 seconds, because I think there's a whole lot of things in here, engineering-wise, I could dispute. But thank you for bringing that up for us. We got it now.
Yeah, and I mean, they're not obligated to provide that to you, but I did think it was fair to provide that to you.
Yeah, I appreciate it. No doubt about it. So there's a personal reason here that we're affected by all this. The second thing is, before we closed on the house, we did a little investigation because there is commercial property behind us. Number one, I'm going to call it one-story buildings that are in there right now. Some of them are reflected in here. They look very much like a house. There's nothing there that it's obstructive. But more importantly, all the signs on the street immediately to the north of us, any sign with those businesses is either mounted on the building or it's a pedestal sign out in front of it. There's no visual intrusion. They're not lighted signs, okay? So we specifically looked at the second thing we looked at, how about all those commercial properties out there on Memorial? And we were told that according to the rules of the PUD, there was a restriction of 30-foot signs. We didn't feel at that time that was going to be any imposition on us. We think and we feel very strongly that a 50-foot sign is unreasonable. Now, interesting enough, that's the first time I saw that video again today. You're going west, okay? Why don't you show us a video going east? I saw some pictures. That's not the same as a video on a car passing by. You're telling me that all their business is going to just get off of Kilpatrick going west? Show it to us from the east what it looks like. You can model that. You can computer that thing and show me a vision from the top of that sign looking right in my back window, and every single residence in Stonebrook you can do that. And it's not been done, and I don't see it. And the other, again, I'm not sure of the page here, but the other diagram in here that absolutely means nothing as far as I'm concerned are these things right here. I can tell you that one side has been referred to countless times that's west of us on Memorial. I went up there and looked at that and looked at the property behind it. I don't have a tape measure with me, and I can't tell you the distance between that sign and the apartments that are there. I believe it's multifamily apartment, but I walked it. And then I went up to where this proposed sign is. As I walked from that sign back to our property, I can tell you there's a significant difference in the number of steps I took. I'd like to see that measured and put on here too, and see what the big difference is. I noticed on the sign of Memorial, you got an exact measurement, but you don't have an exact measurement on the property on west of Memorial to those apartment projects. It's totally different.
Are you referring, there's a sign that's located in front of the Panera Bread Shopping Center. It's a Panera Bread there on Memorial going westbound. Is that the sign you're referring to?
Well,
Do you recall? There's a taller building going in behind that I think is actually going to be a hotel, but...
well, once again, I can't tell from, well, I think it's this sign right here. That's the sign I'm referring to, whatever that is.
The reason I bring that up, I will tell you, and JJ, if I say something that's not accurate, I hope you'll correct me, make me look foolish in front of all these people, but some of the signs that are located along this corridor are actually not accessory signs. They are non-accessory signs, so they're billboards that were allowed to be erected essentially without the city's ability to control that.
Well, I'm not talking about the signs on the east side. I'm talking about the signs west of Hefner Parkway.
Sure. Yeah, and I think, I'm trying to find that picture, but I think that sign that you're referring to in that small thumbnail is the sign I'm referring to that is a non-accessory sign, meaning there was nothing, the city didn't allow that to be erected. It was essentially put up because the turnpike, the frontage on the turnpike qualifies that for ODOT essentially regulations and allows non-accessory. Am I saying all that correctly? Is that?
It still has to be permitted by the city, but it does fall under different regulations than accessory signs.
So I'm pretty certain that's the sign that you're looking at in that thumbnail, just so you understand. Yep.
Yeah, I don't have a clue who approved it. I don't really care who approved it. All I'm concerned about is the impact on the health and safety of our daughter with the sign that is proposed the way it is. All I'm saying is stick with what everybody that agreed to in the original beginning, and everybody was under the understanding, and I've talked to several other homeowners in our area, and they all thought that was the rules. That was the impression that we all had.
Understood.
Okay? Did I go over my 3 minutes?
No, you were fine. Thank you very much, Mr. McCoy. We appreciate you coming down. The next person signed up to speak is Carol McCoy.
Hi, I'm Carol McCoy, also at 3421 Stonebrook Court, and I guess I'm the passionate one, but he stole almost everything I was going to say. But I do have a daughter who's 37 years old. She suffered from a traumatic brain injury 3.5 years ago. She, and like my husband said, she requires a certain amount of dark sleep, not just a nap in the living room. So that is why we chose a house that had 2 stories, because she could have her privacy for a 37-year-old. And upstairs away from mom and dad. We chose the room, again, like my husband said, because of its location. She has heavy shutters on it. Still, with, she needs dark room. But I have pictures of this bucket, and it's hardly representative of what this huge sign is going to be. I have pictures on my phone from my daughter's room of this 50-foot bucket, if you want to see it. You're more than happy to. I'm sorry I don't have a picture for everybody, but I'm happy to share my pictures. The other thing... Anybody
I'd like to see them.
And this is out of the window
This is out of my daughter's room.
that you're talking about? Okay.
Yes. So this is, just so I understand the orientation of this photograph, this was taken from that second-story window, is that correct?
That's correct.
The window, okay.
That's my daughter's bedroom.
Okay. Would you like to see that?
Shade room.
And then, Ms. McCoy, if you could also, in the interest of fairness, could you show them that picture as well? Thank you.
So, back to my little notes, if you don't mind. Like my husband said, and other people have said, that when they bought this property, they knew what they were up against. They knew the rules. When I bought my property, I knew my homeowners association rules. I'm not going to ask them for a basketball goal because I know I can't have one. They should know better. As a big, very successful business, of what they were getting. That's my opinion on that. The Turnpike was there when they bought that business. I worry also about, okay, just like somebody else said, you give you give candy to everybody in the classroom. You don't give it to one guy and say, oh, sorry, none of the rest of you can have it, but Johnny can. You don't tell Mathis Brothers they can have a sign and then tell Holiday Inn and anybody else who follows in suit. No, you can't. And because you know it's going to happen. What's going to happen? More and more light is going to reflect into my daughter's room. So, unless Mathis Brothers can come up with a great big different thing, I suggest that they put a billboard and say, next exit, Mathis Brothers. That's my suggestion and solution to that. So, there you go. That's what I think. And also, these representative of these little people behind a fence, that's really kind of worthless for me, because I can't see that either when I'm in my first floor. But my second floor is what I worry about. Sorry if I took over three.
You're fine. Thank you very much. The next person signed up to speak is Eric Roberts.
Hi. My name is Eric Roberts. I live at 3449 Stonebrook Court, and I'm also one of the developers for the Memorial Business Park. Just on a brief note for myself personally, there is also a big Ashley sign on the west side of their building, which I can see every time I go to my car on my driveway, and it is lit at night. And so now they're proposing to move that sign further west, which is going to stick up over the top of the building, which I will also be able to see, in addition to the big Ashley sign that's on the west of their building that is at probably 25 feet.
Are you talking about an attached sign?
It's an attached sign to the building, which I can see already on their building, and they said their building height's about 28 feet, I believe, on that side. So then you add a 50-foot sign on top of that. That means it's 20-odd feet above that. So I will be, and they're talking about the fan and the V. Well, I'm at the end of the street, and I am way out of that gray zone. And so I will be not only see the Ashley sign, but the LED sign at 50 feet. According to, and I spoke to the gentleman who owns the Holiday Inn, who also did their sign according to the PUD rules of 30 feet and 200 square feet. I spoke to him to see if he wanted to join us in our protest, and he said no, because he actually hopes that you all vote to give them the variance, because he's going to apply for a variance for a 50-foot sign. He told me that personally. The Gold Key sign that they're talking about on MacArthur, the distance is about the distance between that Gold Key sign and the apartments to the rear is about 3 times the distance that it is from the Mathis Brothers proposed sign to Stonebrook. We're talking roughly 3 times the difference. In the purchase contract dated 2013 with Mathis Brothers and MEK Properties, which is us, under Section 3, Conveyance subject to zoning restrictions and covenants and conditions. Buyer agrees that the property shall be conveyed subject to the existing zoning conditions of PUD 249. Covenants, conditions, easements, restrictions, and record thereof. So it was actually in the sales contract that they would follow the rules of PUD 249. And that was just in the sales contract, and then we have the declaration of covenants and restrictions, which Mr. Spradling spoke about earlier, which also covers the ground that the Mathis brothers purchased. And so on top of the variance, they would need to go through and get these covenants as well rescinded through, I believe, through Mr. Spradling said, district court. The Papados property that was mentioned, originally when we sold them, when we sold the original purchaser of that property, it came with a pole sign. When they, Papados, when they purchased the property, they applied for an SPUD, and it's SPUD number 777, which when they got that approved, they actually had to give up their pole sign and go with a monument sign.
Which, just to make clear, that's reflective of subsequent to the adoption of these earlier PUDs, the city had a preference and adopted sign regulations that required monument signs as opposed to pole signs. So if you go back to renegotiate PUD provisions at this point, typically what happens is the city requires you to update that portion of it to a monument sign as opposed to a pole sign. So
Right. So I'm just saying that, they actually went down. They lost their ability for the 30-foot sign at that point. The intent of the whole PUD 249 obviously was a C3 development, commercial, budding residential, step-down PUD. All right, it wasn't heavy C3, but C3 zoning, and so that is why, at that time, those restrictions were put into place. As Mr. Johnson alluded to, the slow-down lane, in order to make the turn, the highway recommends 1,500 feet. They're within 1,000 feet. Okay, I think the 1,500 feet is there for a reason, so that people don't have to dart across 3 lanes and slam on the brakes to hit the exit. So their 50-foot sign being visible at 1,000 feet is well within the inside the limits that was proposed by the highway department, causing probably an undue safety hazard on their department. The Rudy sign that they're alluding to, there is no residential anywhere close to the Rudy sign. What's behind the Rudy sign is storage, climate-controlled self-storage, so there is no effect onto anybody else. And then the information that Mr. McCoy had requested in our small meeting, Mr. Johnson had said that he would provide all the information to Mr. McCoy, and today was the first part that we had. So it's not that we are opposed to any sign. We were just hoping that that they would abide by the rules that everybody else in the whole business park has, is that they would just go by the rules that are set in place. Not no sign, but a 30-foot sign at 200 square feet. And the LED portion, I think we're willing to give them that so they could have a LED sign at 200 square feet at 30 feet. And that is all. Any questions?
Any questions?
I have one question. You were
Yes.
citing Highway Department reg or...
Well, I was going by Mr. Johnson's, and he had said that the 50-foot sign would be visible, and they would have 1,000 feet to change lanes, and I was going off his information.
You're referring to the exhibit that Mr. Johnson provided as showing the highway and the radius limits.
And you were referring to something that said 1,500 feet as
Yeah, he had
opposed to
said that
1,000.
the highway department recommended 1,500 feet, and they were at 1,000 feet, so that's 500 feet within the outer limits of what the highway department had.
So you don't know that particular regulation, is that?
No, I was citing it off of Mr. Johnson, who I'm assuming checked it out and is knowledgeable on that.
Okay.
Thank you, Mr. Roberts.
Thank you.
We appreciate you coming down. The next person I've signed up to speak is Janet Akers. Hopefully I'm saying that correctly.
I'm Janet Akers at 3327 Stonebrook Court. And I back up to well, kind of between the station and the Lazy Boy and the parking lot lights. And it's blinding at night when those come on in our house. And it's like right this way to the Mathis Brothers stores. And like I say, the parking lot lights are bad enough, and you put that big sign up there, it's really going to be blinding. And I agree that Mathis needs to spend some money on the north side of Memorial Road or the Kilpatrick Turnpike and put a sign there that says, exit Mathis Brothers so many feet, where they have a chance to get off, rather than put a big, huge sign. And I know that you say the back part is going to be blacked out. We won't see it. Well, that's not true, because from the side, the sign is angled like this. And I look that way, and I will be able to see that sign, an LED sign going all night long. And so I disapprove of it.
Thank you very much, Ms. Akers. Is there anyone else, that's all the sheets I have. Is there anyone else that would like to be heard on this matter today? If you could come back up. There's, as we say, there's at least 2 people watching at home that want to hear what you have to say.
One thing I forgot to mention that Mr. Spradling had given to Mr. Wilson, we had circulated a petition to the people that were in the neighborhood and people directly affecting the neighborhood, and I forgot to mention that in my previous one. We had over 70 signatures of people that live in and about that sign that would be affected by that sign, that all are in protest.
Just for the matter of the record, I am holding the copy of that petition, which purports to be signed by the people mostly on Stonebrook Court, but there are 72 total signatures expressing opposition to the application. So we do have that, and it was circulated.
I appreciate it.
Is there anyone else that would like to be heard on this matter today? If not, I'm going to give the applicant a chance to respond before I turn it over to the board for questions and comments.
Sure, briefly. A lot was made of the Papado application. I actually represented Papados when they came through with their SPUD. They had a very specific sign package that they wanted. That's what we got approved. So they didn't get strong-armed to get rid of signage. They had a sign package that they desired. That was the sign package that we ultimately got approved by Planning Commission and ultimately City Council. So a lot of the issue made about the brightness. The City Code does have regulations in place that regulate the net level, and it's based upon certain times of the day. As you approach darkness and nighttime, the code requires, and this will have to meet that the illumination and the brightness of the sign correspondingly comes down as it gets dark. And so one of the purposes of these exhibits was you see a similar distance, I believe it's the exact 525 feet, the second to last page, to where you have the 3 kind of nighttime shots. That is looking at a distance similarly situated. You see these blue, yellow, red dots of the 3 houses marked on the previous exhibit, showing you what those houses will see at nighttime. And because of the way that the sign is fanned out, you cannot see the illuminated face of those signs. Now, certainly there are people outside of that cone, but the illuminated face, again, drops in terms of its brightness once you get past a certain period of time. A lot was made about the other views. I'm willing to stipulate that our hardship is, frankly, limited to that westbound travel. You can see the sign from the other elements. It's the westbound Kilpatrick Turnpike where the hardship lies. That is where we have blockage from not only the turnpike, but the thing that our video doesn't show is the sign's actually behind the trees. So this was shot, I believe, this week. At 40 feet, not only is it partially blocked from the highway embankment, but it's essentially fully blocked from the months that it's warm and the trees are bloomed. You can see on that image there, you have significant landscaping that's on that embankment. So the 40-foot sign is essentially completely blocked for the summer months. Perhaps you have a partial wintertime view. on the westbound, but that is the hardship. The hardship is the ordinance is in place. That was not in place at the time the ordinance was passed, and because of that ordinance limitation to the 30-foot, you cannot see the sign in a proper way to be able to exit the highway on the westbound traffic. So unlike zoning cases and where certainly emotion is something that is common, one thing that's different about this process is you're guided by the statutes. You're guided by the statutory elements, not what you're guided by perhaps in a zoning case. I would submit that what we have provided and shown through exhibits, video, and oral argument is that each of those 4 criteria we meet. I didn't hear anything that was presented to the board that rebutted that we met any of these, other than just saying that we don't, but I didn't see any evidence or any data to say we don't meet the 4 elements necessary to have a variance granted. Certainly, contract provisions, covenants have absolutely no relevance whatsoever to this board's decision. That is a matter of private jurisdiction, and if they believe that there's something they can pursue on that element, then they're certainly entitled to do so. But what you're left with is applying the 4 elements to the data and the evidence presented to you, and based upon that, I would submit that we have met those conditions and would ask for your support in our variance application. Be happy to answer any questions.
Board members? We'll do that at the end, if you don't mind, Mr. Spradling. I'd like to get some board member comments at this point.
Several things. I think you should go back to the Plan Commission. I think the purpose of this, even though it is old, it deals with a very landmark issue that may be coming up with future cases. I think that needs to be addressed by them on an amendment or something to your PUD to address the 50 feet from 30 or whatever. The other thing, I don't think you have a hardship proof by saying you can't see the sign from the turnpike. I just don't know that that's an automatic right of hardship, so to be able to see every single sign from all the businesses that are on the adjacent. And therefore, I can't favor this.
If I could respond on the planning issue, if we did it, what we'd hear from the chair, and likely everyone else, is the zoning process is not set up to just handle signage. You can't amend it. We couldn't go amend this because we'd have to rezone it, and it wouldn't be favored, because that's why we have this process.
Yeah, so this was mentioned earlier. You mentioned this earlier when you kind of started your remarks. Historically, the Planning Commission has said, do not bring us an amendment to a PUD or an SPUD for a sign issue only. There's a lot of reasons for that, but I have to say, in this instance, I'm not persuaded that even though I probably bear the brunt of that frustration, I'm not so sure that I don't agree with that assessment here. I don't agree with Ms. Lewis that there's not a hardship. I think you could make the argument that there's a hardship that the applicant didn't bring on itself, just from the standpoint that that berm wasn't contemplated, the turnpike wasn't contemplated when that signage was agreed to. And one of the things that I hear a lot, and it's really started to frustrate me as a matter of the Planning Commission, and if anybody ever tells you this, you can argue with them, is that each one of those things in a PUD is specifically negotiated. That's simply not true. I have been on the Planning Commission now for 5 or 6 months. There are lots of times when issues are negotiated. Signage is particularly heavily negotiated. A lot of things are just put on the thing and swept through, and then all of a sudden you realize there's a problem. And that's because of instances like adopting the standard C3 signage codes, which was done here within this PUD that limited the sign to 30 feet, and then they bring a turnpike through, berm it up so they can get underpasses and things like that. And the argument that a 30-foot sign is not sufficient in the ordinance is, frankly, it's persuasive to me. I'm even persuaded that the particular property here is peculiar. It abuts a rounding highway that's highly elevated. It is beneath that berm. It's large. There's a lot of large-scale commercial development that's there. That is persuasive to me. Where I actually run into trouble, and I actually think the applicant has demonstrated that the fourth element, which is minimum necessary, if we would agree that the purpose of eliminating the hardship, which would be the turnpike that came through and raised that, would be to allow the sign visibility, which I'm not sure they're entitled to. Whoever made that comment, I think I'm in agreement with you there. I'm not sure that's what they're entitled to, but it's an argument. Raising it to 50 feet certainly would eliminate that. So what I have trouble with here for me is that relief, if granted, would not cause substantial detriment to the public good or impair the purpose of the ordinance that relates to the comprehensive plan. And one of the things that the comprehensive plan does is it essentially lays out mitigating factors and things that should be considered when commercial uses abut residential uses. I live along the Memorial Corridor. I'm very familiar with all of these signs that you guys are talking about. There's one sign in particular, if it has a nit reader, it's broken. But I sympathize with the arguments you guys are making and the consternation and concern there. I'm also persuaded by 72 signatures that there's a public good issue here that probably needs to be addressed. And so while I'll probably get a little bit harassed over a signage application that came back to Planning Commission for one issue, I think I would defend that here based on these signatures and the belief that a public good argument is to be made. To me, that's a legislative process. It's not a board process. And I'm not persuaded that the third element has been met. So for me, that's where the issue lies.
Well, it seems to me that from the standpoint of the hardship, this property was purchased in 2013, and the turnpike was there, the PUD was there, everybody knew what was going on. And so I don't think they meet the first element, and I certainly don't think that they, on the public good, that's an issue.
If I can, the test is the application of the ordinance, not when a particular person comes and buys. It's the ordinance at issue. The ordinance predates the turnpike, not when this buyer came and bought. You can't test it now. It's testing the ordinance, and that ordinance predates the turnpike.
I think the argument that Mr. Donaldson is making and some of the protestants have made that, look, if this were an issue, why not have this discussion? Why not have a rezoning discussion as a condition of due diligence before you buy a property? I understand that argument. In this instance, I don't agree with it, but I understand the argument because I agree with Councilor Box. The test is simply the ordinance. It's not about the person who bought the property and when. It's the ordinance itself. And so there could be an argument that they knew the ordinance on its face gave them the ability to come and have this argument. I think what they didn't anticipate when they did that, if that was their strategy, is that 72 homeowners would stand up and say that that's a problem. And at least as it relates to my view of it, that's an element that remains to be met here. We have a public good concern and we have a comp plan concern by the sort of the lack of mitigating factors that have been pointed out. So it's pretty clear to me that this is not moving forward from this process. If there's other discussion needs to be had, otherwise I'd call for a motion.
Yeah, I move to deny the application in case number 14451 for the reasons it does not meet the statutory elements required.
A second.
I have a motion and a second to deny the variance request for case number 14451. Please cast your votes, please.
Thanks.
The application is denied.
Item number 2, case number 14467, request for a variance to the maximum display area allowed for an attached sign in C3 Community Commercial District located at 2563 West Memorial Road.
Brandon Kuhn with Hewitt Zollers representing the applicant. We were here 2 weeks ago and have since revised our request and removed 2 signs that are on the north side of that building that abut the residential area. That was one of the concerns in the last meeting, was all the residential to the north, so we have taken off those 2 signs. So what we are left with is a total of 738 square feet. I think we were over 1,200 square feet before, so we have dropped that drastically, and I'm happy to answer any questions.
I bet you're super excited to have the next sign application after that. Huh? Yeah. Yeah. I appreciate you pointing out that you've eliminated the signs that were facing the residential. Right. Well timed, sir. Well timed. Yeah. Mm-hmm. We've seen the application before, and one thing I'll say just comment-wise, is there anyone here that wanted to be heard on this application? We're down to 2, and there's 2 cases, so something tells me no. It was really about, have we done the minimum amount to alleviate your argument on the hardship? At least that's what it was for me. I can't speak for these folks. But to that end, tell me about the sign reductions and why you made those. And I mean, we shaved 400 square feet off the application in 2 weeks, so walk me through that.
Right. So, I mean, basically, we were just trying to, we didn't have, I didn't feel like we got a whole lot of direction on where we needed to go based on last meeting. So it was just a general discussion with the client on, you know, what could you do and still be able to have the, you know, the outward facing and the marketing that you need. And so, and I did bring up, one of the comments was, you know, 2 of these signs that will be lit that's facing the residential area, and they said, well, why don't we, well, let's get rid of those. That will drastically reduce our square footage, but still give us the signs on the other sides of the building. So basically what we have is, we have 678 square feet of what I'm going to call accessory signage. So we have two signs that will advertise the Lifetime Tennis, and we have 2 signs that will advertise Lifetime Fitness. And then the other 3 signs, one of them is the on the pool deck, which is just a 22 square foot sign, and the other 2 are the Life Cafe and the Life Spa signs that are on either side of the entrance, which is, you know, just to help the public who doesn't have to be members know where they can go to access those services.
Board members, questions or comments for the applicant?
These remaining signs, those didn't change their size at all, or did they?
No.
Okay, so it's just the removal of the 2 signs that lowered square footage?
Right.
Okay.
Walk me through the argument again about how this is 2 structures.
Okay, so the main structure is the fitness facility, the basically all their other services. The building that's on the east is 8 indoor tennis courts. And when we first started this project, and technically it's 2 separate structures. Now they're pushed together and they're combined, but structurally it's actually 2 separate buildings. And most of the time when they build these facilities, they're separated more with a link in between the 2. But it's actually 2 separate structures. It does look like one because they're pushed together.
Okay. Board members, other questions or comments or discussion? If not, I'll leave it up to you to take or make a motion.
I move that we approve the variance.
As amended? As it is?
As amended.
Second.
I have a motion and a second to approve the variance for case number 14467 on the basis that all the elements for a variance have been met. Please cast your votes, please. And the application is approved. Thank you.
Item number 3, case number 14474, request for a variance to the minimum 25-foot front yard setback in PUD 1172 district located at 11032 Northwest 8th Street.
Hi, my name is Zach Holland, 3232 Hardwick Road with Tabor Built Homes. And this issue came up during the planning phase of building this home when we build in several additions that have in Oklahoma City that have a 20-foot front build line. This addition, Chisholm Crossing Phase 2, is a 25-foot build line on the final plat, and that incorrect labeling of the build line in the plans was just never caught through the construction process. So this home is now 100% complete. It's under a contract to be sold. There's a buyer. The closing's pending, waiting the result of this meeting. And so that's the issue, and that's the variance that we're requesting. That when we build a home, we always try and set back at least 1 foot from the build line. So that's why it's 4 feet over instead of 5 feet over. Driving down that road, looking at the streetscape, if you're not being very aware that that house has an issue, there's no impact to the neighbors. It doesn't visually impact the streetscape. And requesting a variance.
So that was one of the things I had asked staff for clarification, because this is the exhibit that I have that shows me what exists on this property right now. You can't see it from there, but they're just blank pieces of land. their houses have been built along that street?
Yes.
And so the building line is pretty well established?
Yes.
Right? It just, when our stem wall guys showed up to pour, we missed the line.
Correct.
Yeah. Is there anyone here that wants to be heard on this matter? I'm assuming not. There's one person left and one application. So, I get it. I mean, these things happen. It's pretty clear that if there were objections from people on the street that it did affect the streetscape, that they would be here to make that argument, and they're not. So, board members, questions or comments for the applicant?
I would just ask that if the applicant has a photo exhibit to show how it appears is built as part of his application. And all we have is just the drawing.
Unfortunately, I do not.
I'm curious if there's any benefit to missing like this. What I don't want to happen is people just say, oh, we'll just do this and then get a variance.
No, your point is very well taken. So I don't know why we haven't seen a lot of these applications recently. In my time since 2014, when I came on the board, we did see them. They're usually on corner lots where the house is turned and a small corner gets poured over the building line and they don't know it, and they come in and they're a foot triangle over the edge. I have to say this is the first one that I can recall seeing where we're on an inline row of homes, straightaway rectangular lot, and we miss it, especially by 4 feet. Again, I think my issue with this would be, I guess there's one option. We could shave 4 feet off the front of the garage and require the buyers to have Mini Coopers. Or if there were people that really thought this affected the comp plan or the public good, they would have shown up to make those remarks.
Right.
So it gets challenging. We don't see them a lot. I don't recall having seen Tabor in here, making these comments, on every third house they build or anything like that.
Right. And I understand your point there. We're building probably close to 200 homes in this addition. So this isn't just a one-off thing where we're hoping to save some cost on a home. We understand the issue and the need to build behind the build line, and it was a mistake.
Yeah, with a skeptical eye toward the future, would approve.
I sure hope you don't have to come back for being 4 foot over the build line in this neighborhood. You'll have a lot of explaining to do at this point, right?
Correct.
Yeah. Other discussion or motions?
I move that we approve the variance.
Second.
I have a reluctant motion and second to approve the variance for case number 14474 on the grounds that all the elements of a variance have been met. Please cast your votes, please. And the application is approved.
Thank you. Item number 4, case number 14476, request for a variance to permit a detached accessory structure with walls constructed of exterior metal finish that exceed 10 feet in height and exceeding the maximum size of 1,000 square feet in the R1 single-family residential district located at 1304 Sunway Street.
My name is John Ray at 1304 Sunway, asking for a variance for the height and the size of a metal building. If you see the pictures of an old shed, I'm in Sunway Valley Addition. It's an older area. There's been other variances. I should have taken pictures of other buildings, but if you know the area, it's been there for 50 years, and there's additional metal buildings there, so I'm not really changing anything that is new for the neighborhood. I just need a taller one. If you'll scroll, if there's another picture there, did I send one for the shows the old building? Let's go to picture number, that's the handicap van. That's a fifth wheel. And there's the old building. That's the old one. It's probably older than a couple of people up there on the stage. It's 8 foot. It just doesn't do, I can't even put a pickup in there. So I just need a height variance and a size variance to just get everything on the property.
Well, if I'm not mistaken, the height variance is required because the exterior walls are metal. Is that correct?
Correct.
So if they weren't metal, then you could build that height. Is that correct?
I'm not the professional here.
Well, that's a question for staff. I'm just,
Okay.
You could build up to the height of the primary structure. You couldn't exceed the height of the house.
I understand that part. If you scroll back, my backyard has got a retaining wall. Scroll back right there, you can see it to the left where I'm standing. There's a 2.5-foot brick wall for the backyard drops lower than the front, and the house, if you go to another picture, is well above the height limit. So the main structure, now as far as a brick facade or something like that, no, I don't know what that would cost. I was going to do the two-tone metal for the wainscot, and two-tone gray to match the house, but basically that's it.
You made reference, and hopefully you were here for the first case, to other variances. We don't know what those variances were. I understand that when this neighborhood was annexed into the city some time ago, that there were issues with the way that the lot was designed and developed, and it was brought in and then allowed to be rezoned sort of ad hoc, and so it created some problems. I don't know if those variances were related to setback issues and other problems like that, or there were specific buildings. And again, as I said in the first, it doesn't matter. All these cases, anytime someone comes in, every case must meet those elements on their own and stand on their own. And when I looked at an aerial of this area, because I saw in the application where you made reference that there are other structures and there have been other variances, I can't, and I didn't go out there with a tape measure and go in people's backyards and tape them off, but it didn't appear to me, there were a lot of accessory structures, but it didn't appear to me that any of them were in excess of 1,500 square feet or in excess of 1,000 square feet. And that's, to your point, that's, I wonder if there are, or if they actually meet code and you just weren't aware of that.
For the size of the yards, I'm not a professional at it, but if the size of the issue, I really need the 14-foot door for a fifth wheel to pull in that's 13.5 feet tall. So I can go smaller, 1,300 square feet, 1,200 is the variant, the limit. I was trying to get a little more than that to get around inside the building.
Well, again, remember, our issue here is to evaluate the application on the basis of the elements of a variance. And one of them is that we put in an application for 1,500 feet, but 12 is okay. And my question, by your admission, 12 is okay. My other issue is just that because we want to build metal, we're limited on our height. If we didn't want to build metal, and that's one of the things that ordinance is seeking to avoid, is the construction of metal buildings that exceed a certain height that you can see. That's literally one of the intentions of that ordinance. So I'm having a hard time understanding what would be peculiar or what a hardship would be that would make sense to approve a metal building in excess of what the code would allow in this case.
Well, my question is, does the front of the building have to be brick, or what is the rule on what part of it has to be brick?
Defer to staff on that question.
Well, the permit was denied on the wall height, not the building height, but the wall height, because it's metal, and in the size. So it's not denied because the permit was not denied because of the height of the building. If it had been wood walls, then they wouldn't have had a problem. It had
Okay, but
metal.
I think somebody asked the question, if it had a brick facade on the front, would that affect the height limit?
Well, again, I'll have to defer to staff to correct me here when I say something that's incorrect, but the height of the wall is based on the exterior construction. So it's not a matter of one wall being brick or wood in this case. It's a matter of the building being constructed. Is that correct?
You've got two height limits here. If the building side walls are metal, they can't exceed 10 feet in height. If it's built of anything other than metal, the building can be built to a height no taller than the house.
No taller than the house.
Yeah. Those are your two limits.
Here would be my honest recommendation to you. You don't have to do this, but I'll make it anyway. I think if I were you, I would consider taking a continuance on this case.
Okay.
And trying to work through, are there other alternatives to your building materials that you can use to comply with the ordinance or to solve the height limitation based on the materials you're choosing? Or, in the alternative, and additionally, I would say, what is the minimum amount above the stipulated allowance and ordinance that you need to eliminate your hardship? That, I would take more than 2 weeks to work through that. Again, that's entirely up to you, but
That's fine. We'll do a continuance. And I'll research some other materials.
Okay, so the meeting would be 2 weeks and 4 weeks. Would you prefer the 4 weeks?
What day would it be exactly?
June the 7th would be the meeting 4 weeks from now.
Let's go, let me try 2 weeks, because 4 weeks I'll be out of town.
Oh, do we have, no, we have a second meeting in May. We got May 17th. Yeah, so May the 17th?
May 17th will be fine.
Okay.
Move to continue the application until May the 17th in case number 14477.
I second.
I have a motion and a second to continue case number 1447, it's actually 76, until May 17th, 2018. Please cast your votes. And the application is continued.
Thank you.
Thank you very much. Appreciate you coming down this afternoon.
Thank you.
Last item was continued, so moving through the rest of the items on the docket, communication and reports. Board members, any comments on anything? Municipal counselor? Citizens to be heard? None. And if there's no other new business to discuss, I'd take a motion to adjourn.
I'll move to adjourn.
Second.
And we are adjourned.